Hi, everyone. Thank you for joining us over your lunch hour today for another one of our West webinars. My name is Lola Adebogan, and I am West Marketing and Admin Assistant. Our topic today is how to deal with creditors. This is the second part of our five-part webinar series titled The Top 5 Legal Matters for Entrepreneurs to Consider. The remaining three topics in this series will be taking place every Wednesday in January. While I'm talking, I'll leave this slide up with our 5 legal topics to give you a sneak peek of what's to come. Registration is now open for the rest of the webinar in this series. Today's webinar will be presented by Nicholas Conlon, who is an associate at W Law LLP. If you have any questions for Nicholas as we go through the presentation, please feel free to submit them in the Q&A box, not the regular chat box. However, do feel free to use the regular chat box to introduce yourself and tell us a bit about your business. And as always, this webinar is being recorded and will be available for on-demand viewing. You'll receive an email tomorrow at this time with a link to the recording. With that, I'll pass it over to Nicholas now to begin the presentation.
Yes, good afternoon, everyone. I am your presenter, Nicholas Conlon, for the first part of the legal series put on by the Women Entrepreneurs of Saskatchewan. Today, I will be dealing with the topic of how to deal with creditors in both a general and specific sense, starting with the proviso that a business is built for the long term, pay their debts when they become due, and typically manage to avoid costly litigation as a result. That said, life and business, particularly in these unprecedented times, have made this proviso harder to follow for many businesses, and this is often through no fault of their own. In such cases, being able to effectively deal with creditors and turn down the temperature, so to speak, is essential. So, to slide 2 here. In discussing how to deal with your creditors, I do intend to address questions at the end, but the 4 topics which I will be addressing for you today, which I believe should give a solid legal foundation for thinking about debts that may arise in the running of a business, would be firstly prioritizing debts, and specifically the important distinction between secured and unsecured debt, and what that means for a business in terms of how a debt is likely to be enforced by a creditor. And next, I'll be dealing with limitation periods. And this will discuss what it means in terms, or what they mean, in terms of the enforcement and in Saskatchewan, even the very existence of a debt. Next, I'll be dealing with debt, due, and owing actions. And now when your debt is being pursued through the courts, it is important to know the various stages that such an action will typically progress through, so that a business person can have a good understanding of what options are available at the various stages. Lastly, I'll be discussing avoiding bankruptcy. And I'll be addressing potentially how a bankruptcy may be avoided. The reason I've chosen to frame my last topic in this way is simply because while bankruptcy may ultimately be necessary, it does effectively end a business and is typically reserved as a last resort. And the hope of this seminar is to provide enough foundation in effectively dealing with creditors such that this result can be avoided if at all possible. So before getting into specifics about the different types of debts and the issues surrounding them, I think it's important to first address the different methods that may be employed for simply resolving outstanding debts with creditors, including paying the entire balance outstanding in a single payment or in installment payments. In most cases, if you legitimately owe a debt and it has been in default for less than 5 months and you can't afford to pay it, it is likely in your best interest to do so. This is especially the case if you're going to need to borrow large amounts of money at reasonable interest rates in the future. A second option is to settle the debts for less than the amount owing by negotiating a lump sum payment. Generally speaking, you can usually negotiate lump sum settlements for unsecured consumer debts, including credit cards, personal loans, lines of credit, and utilities. However, it is difficult, if not impossible, to negotiate settlement with your secured creditors and with the government. A third option would be to pay the entire balance owing using a debt management plan arranged through a credit counseling agency. Now, many times businesses and persons would be able to afford to repay their debts if given several years to do so. And that's where a debt management plan would come in. On this point, I would note that if you decide to arrange a debt management plan, you should consider using a lower cost nonprofit credit counseling agency as opposed to a for-profit one, which are typically advertised. The reason for that is simple. The nonprofit credit counseling agency, in my experience, have been more effective and cheaper. The fourth option is to arrange a consumer proposal or a personal bankruptcy with a bankruptcy trustee, which I'll discuss in detail in my last slides. So when we begin to first consider, or when you begin to first consider your or your company's current debt situation, it is important to start by prioritizing the different types of debts that you'll be dealing with, namely secured and unsecured debts. So with secured debts, your creditor has collateral which it can turn to if you fail to repay your account. A good example of a secured debt is a loan you take out on a lease or the purchase of a car. The lender will usually put a lien on the vehicle, making the car or vehicle your collateral. So if you fail to make payments to your lender, they can simply repossess that collateral, being the car. And lenders will usually insist on becoming secured creditors for large personal loans or lines of credit, either to yourself or to your business. Now, if a collection agency is calling you, it's probable that you're talking about an unsecured debt, which is debt where your creditor has no collateral if you do not repay it. The common types of unsecured debts are credit cards and most debts that are worth less than $10,000, such as bank overdrafts, lines of credit, and personal loans. With respect to secured debts, it's important that these are prioritized because of the relative ease with which they can be enforced in response to a failure to pay these types of debts, namely the seizure of an asset. So in order to deal with a debt effectively, it's really important to know if the debt's secured. However, this can be difficult because over the past several years, the banking industry has increasingly been converting unsecured debt into secured debt through what are called master credit agreements. Under such an agreement, the financial institution makes a certain amount of credit available to the customer, and the customer agrees to provide collateral for this debt. If you are unsure whether you have signed a master credit agreement with a financial institution, you should ask for documentation regarding your loans or sources of credit. Moving to slide 6, for unsecured debts, the major consideration beyond reputation and the continued ability to do business with the creditor is how the creditor is going to enforce that debt, if at all. And with unsecured debts, typically the only way to enforce the debt claim is through litigation. because you don't have collateral in place which you can simply seize without the necessity of litigation. And just for your information, in terms of seizing an asset, typically what that requires is simply a notice of seizure, which can be provided to the sheriff, who can then go and seize the collateral for a creditor. So it makes the process very simple. But with unsecured debts, it, of course, as I'm speaking about here, involves litigation. So that said, large creditors in Canada will typically only try to collect overdue accounts on their own for about 3 to 6 months before forwarding a claim to a collections agency. And they are usually unwilling to negotiate on the debt during this initial 6-month time frame. However, once a claim is with a collections agency, the agency is usually given some instruction to accept some level of settlement less than the amount presently owing. This is part of why it is important to know who is calling you or your business to enforce the debt. Because if it's a collection agency, then the possibility of settlement may be more favorable. Now, it's also important because if it's a second, third, or even fourth collection agency, then the possibility of settlement typically increases the further down the line the debt goes. It's also important to get crystal clear on which debt they're contacting you about and the amount outstanding. This is important because the onus is on the person attempting to enforce the debt to prove its existence, and as a debtor, you should not allow anyone to ask you for money based on a guesstimate of the amount outstanding. So as discussed in this slide, in the event the outstanding debt has been sent to a collection agency, the odds of you being sued are quite low. That said, unpaid debts will have a negative impact on your credit rating for up to 6 years from the date of your last payment. So the goal may be to use the leverage of your creditor never intending to sue you as a way to negotiate a favorable settlement on your debt. That said, when first dealing with a collections agent, in my experience on behalf of clients, it can be very unpleasant and at times even disrespectful. That is why I have included on this slide a list of prohibitions to keep in mind regarding collections agents. If you believe a collection agent is violating any of these prohibitions, one effective means of addressing the same is to contact the province's Consumer Protection Division to file a formal complaint. As you can see in this slide, collection agencies in Saskatchewan or operating in Saskatchewan are bound by the Collection Agents Act. And this is where these specific prohibitions come from. And so I'd urge you, if you're ever being contacted by a collections agent and you do feel that they're being unnecessarily aggressive, to review this act in detail so that you know what your actual rights are and can effectively enforce them if necessary. So another important consideration in deciding how and if you're going to negotiate on a debt is whether or not a limitation period has or is about to expire. And this is important because a creditor effectively loses the ability to collect a debt from a person after a limitation period expires, unless the creditor sues and the debtor fails to file an appropriate defense with the court, or the debtor chooses to pay the debt voluntarily. So in Saskatchewan, the standard limitation period is 2 years. However, this varies from province to province. So it's important to know the jurisdiction where your debt originates and where it is likely to be enforced. The statute of limitations, that 2-year limitation period, it begins to run on the date of your default. This is usually the date of your last payment on the specific account, or the date of your or your agent's last written acknowledgement of your indebtedness, whichever occurs last. So the two cases that I've included on this slide are intended to highlight the fact that a claim is discoverable for the purposes of activating a limitation period when a reasonable person would know about a potential claim, but not necessarily the success of that claim. The reason I've chosen to include these two cases in discussing discoverability is because it has a applicability beyond simple debt due and owing actions, and particularly if a business is seeking to potentially make a claim or enforce its own debts, it's important to keep in mind that you don't need to have an assurance of success to start a claim against someone, and you're better off not sitting on your rights or waiting to figure out that your potential claim would be 100% successful before you start litigation, simply because the fact is, as it states in Johnson and Studley there, the later discovery of facts which change a borderline claim into a viable one does give rise to the discoverability principle, simply meaning that you don't need to have 100% assuredness of success before you commence an action, and it's important to always keep these in mind when you have your own debts outstanding. So these are some practical points to consider, and one of them is that in Saskatchewan, the 2-year limitation period is substantive and not merely procedural. So if you're dealing with the expiration of a limitation period in Saskatchewan, then the date on which the limitation period expires, the debt is extinguished and the debt no longer exists. It is then no longer lawful for your creditor or its collection agent to attempt to collect the account from you. The reason this is important is that in other provinces, a limitation period may simply provide you with a defense to a debt due and owing claim, something that you can rely upon as a debtor to say, I have a valid defense to this claim. However, in Saskatchewan, it actually extinguishes the debt entirely. So from a practical perspective, let's take a mortgage, for instance. If that mortgage debt, if it's not enforced appropriately and the limitation period runs out on it, the effect of that is that the registration of that mortgage against title to the home, that in effect disappears as well. It's as if the debt was completely extinguished. It's not a matter of simply, well, okay, now you have a defense to this claim, and that is a change in the case law from Saskatchewan. One of those cases I've cited would be Newdorf Estates, and there the court just makes clear that the expiration of a limitation period served not only to bar the court action, but also to extinguish the debt to which the limitation period applied. And then I've mentioned another case below, which discusses what happens to a creditor who's registered an interest in property but allowed their debt to expire, or their debt claim to expire. And in this case, the court found, well, now actually your registration at land titles, that has to expire as well. So looking at slide 11 here, I talk about things that can extend the limitation period. And this is important because people often unwittingly extend limitation periods through things like emails and part payments. And basically there are two things you can do before the expiration of your limitation period to restart the clock on the statute of limitations. One of them is to make a partial payment to your creditor, and the other is to make a written acknowledgement of the debt. The reason I mention that is because, again, emails often serve now as the effective means of acknowledging a debt. And I guess one thing I would point out there, an acknowledgement of a debt is interpreted quite liberally by the courts, meaning that even if you would send an email saying, that's not the full amount owing, or sorry, that's not the correct amount owing. In fact, I only borrowed X amount and I think interest would be this. Just the fact that you would acknowledge that there could be an amount owing there, even though you don't cite the specific amount and actually disagree with the specific amount they're claiming, you have in effect through such an email extended your limitation period. Another good example is if you're trying to get a refinancing and you or your agent contacts the creditor and asks, for instance, what is the amount outstanding here? Okay, well, by asking what the amount outstanding is, you have again acknowledged the debt in writing, because I'm presuming you had sent an email, and any signature or indication that can give the court comfort that it came from you or your agent's email effectively serves as a signature for the purposes of the Limitations Act. So slide 12, what I talk about here is the fact that should you or your company find yourself in litigation over a debt claim, it's important to understand that for non-secured debt claims, the first step in either a Queen's Bench or a small claims action is typically typically the service of a document called a statement of claim. If the debt is under $30,000, then it's most likely that the creditor is going to proceed through small claims, which is a little bit more streamlined, as you can see from the stages there, than the Court of Queen's Bench. And the reason for this is simply that the amounts you're dealing with at small claims are smaller, and the Court of Queen's Bench exists to handle the larger claims. I guess the most important piece of advice I can provide you with is, should you receive a statement of claim or any other court document, is not to ignore such documents. Typically, these documents are going to tell you exactly when you are expected to respond and have serious consequences for failing to respond. There's no advantage to be gained by waiting to get a lawyer involved or waiting to respond to a claim. And the failure to do so can result in any defense you may have being lost for something as avoidable as a missed timeline. So I guess in looking at these different steps here, one thing I would urge you to keep in mind is that throughout any of these steps, even at the trial stage, you have the ability to reach out to the other side and make an offer to settle the debt being claimed. This is important because although I've put in place here different stages, the fact remains that after the attendance of mandatory mediation for a Court of Queen's Bench action, the debtor on a simple debt due and owing claim doesn't necessarily have to go through the remaining 3 to 6 steps there. They can simply bring what's called an application for summary judgment, which is where they essentially try to convince the court that the case is simple enough and the facts aren't in dispute such that the court can be reasonably confident in making a just decision. So although I've outlined 6 stages to a typical Court of Queen's Bench action, it's important to know that potentially based on how simple your claim or the claim against you is, there is an ability to short circuit that process. That said, in looking at all these different stages here, it's important to keep in mind that in terms of your negotiating and leverage, with respect to legal fees that are going to be incurred in enforcing on a debt due and owing claim that's unsecured, your greatest ability sort of to negotiate on those is at the beginning of a claim, as opposed to at the end stages, which for both is trial, simply because at that point, there's the prospect of those legal fees, but they haven't yet been incurred. So going to slide 13, As discussed in greater detail as we move forward through the remaining slides, one of the main reasons people seek to avoid bankruptcy is the serious negative implications that this is going to have on your credit score. The two major credit reporting agencies that assign people credit scores and ratings to rate their credit worthiness are TransUnion and Equifax. A number of factors are taken into consideration in determining your credit score, including your repayment history, your current debt level, credit applications and inquiries, age and marital status, home ownership, occupation and employment stability, and length of time at your current residence. The higher your credit score, the more you are considered to be a good credit risk. And a credit report, on the other hand, lists some, but perhaps not all, of your creditors, the amounts creditors say is owing, and how current you are on these obligations. It may also show any judgments against you. So I guess what's an important takeaway from this slide would be the fact that the people influencing your credit score the most are in fact your creditors, who are submitting this information to the credit agencies I've mentioned. And that's why it's particularly important, if you identify errors on your report, that you contact these credit bureaus within 30 days, because if in fact you raise a concern, they have 30 days to investigate your concerns. And if they cannot determine the validity of an error, once the 30-day time frame is passed, then they are legally obliged to remove the item from your credit report. I say this because I have been contacted by clients in the past with errors on their credit reports, put there specifically by disaffected creditors whose claim either expired or they didn't have a claim at all in our opinion, and they never filed any lawsuit regarding it. And we would have asserted they would have been unsuccessful if they had. And contacting the credit agencies was the most effective thing we could do for the client, simply because it did result in those spurious claims being removed. But again, that's why it's important that you should check your credit report every 6 months, particularly if you're having an ongoing dispute with a creditor, to ensure that you've sort of told the credit bureaus your side of the story, force them to investigate it. And the safest course of action for them in that case, where there is ongoing litigation, is to typically then remove that from your credit report as an error until a final judgment on the matter. So a credit rating, which I have listed here, is a number assigned to each item that appears on your credit report between R1 and R9. There's no such thing as R6. And if you look at the chart on this slide, you can see what each of these numbers means. And I'll just talk about the last one. Once your account is in 6 months in arrears, it'll typically become an R9 and be written off as bad debt and sent to a collection agency for collection. Once you have one or more R9s on your credit report, it's going to impact your credit score and lower it. Again, always keep in mind that the information on your credit report is only as good as the information being provided by the creditors. So I intend to touch on the issue of bankruptcies briefly with a large dose of caution, namely because it is truly a last resort reserved for the most dire of situations. If you file for bankruptcy for the first time, it will appear on your credit report for 6 years following your bankruptcy discharge. And if you file a second time, it will appear on your credit report for 14 years. It is important to note that the Office of Superintendent of Bankruptcy maintains a registry of the names of persons who have obtained a certificate of discharge from bankruptcy. It is possible for a member of the public to do a name search and to confirm that a specific individual has successfully filed for personal bankruptcy at some point in the past. And so if protecting your public reputation is important to you, it's obviously something you want to consider in deciding whether or not you want to take sort of the most dire action and file for a bankruptcy, although in some cases they are simply unavoidable. Finally, I would also point out that a prior bankruptcy may preclude you from different jobs and professions that handle trust monies, including lawyers and banking professionals. That said, most, but not all, unsecured debts are forgiven when you obtain a discharge from your bankruptcy. The following debts, however, are not forgiven. These include spousal and child support obligations, student loans where you have ceased attending school full-time for less than 7 years, court fines, and debts involving fraud. So typically what you'll see in terms of litigation is that if someone's debt would have been discharged from the bankruptcy, but they still want to sue on it, they will typically modify their claim against the former bankrupt person to include a claim for fraud. That's a strategy I've seen to try and get around it. Of course, they still have to prove there was a fraud, and the standard on that is high, and for good reason. It's a very serious allegation. A bankruptcy also does not relieve you of your legal obligation to pay secured creditors, meaning that these secured creditors remain able to seize the collateral should you default on your payments. So if you have a car loan and you go bankrupt, well, the secured creditor, providing they have a lien on your vehicle, still has the ability to enforce that lien simply by seizing the asset. Now, before getting into a consumer proposal, I think it's important to discuss the role of a bankruptcy trustee, who's the person who walks individuals and companies step by step through the process of filing for bankruptcy or making a consumer proposal. A bankruptcy trustee has a significant amount of educational training and practical experience. As I once explained to a stressed client going through one of these, a bankruptcy trustee is not your advocate. His or her obligations arise under the Bankruptcy and Insolvency Act, to the superintendent of bankruptcy, to your creditors, and to you. So if you file for personal bankruptcy or make a consumer proposal, in many respects, the bankruptcy trustee acts like a judge at a trial in which the debtor is one party and the other party is his or her creditors. Obviously, they have conflicting interests, and essentially the bankruptcy trustee is attempting to come to a just result for both of them. To make a consumer proposal or to file for personal bankruptcy, you must be insolvent. You are insolvent if the total dollar value of your debts is greater than the total dollar value of your assets, and you are unable to pay your financial obligations as they become due. So at your initial meeting with a bankruptcy trustee, the trustee will want to determine whether you're insolvent. So you'll typically complete both a list of your assets and debts, which is known as your statement of affairs. Provided you qualify, the trustee will work with the debtor then to determine how much money they can afford to pay creditors each month. And this is specifically talking about a consumer proposal. So after this proposal is completed, it is then filed with the Office of Superintendent of Bankruptcy. Now, a consumer proposal must be approved by the simple majority of your unsecured creditors, and each creditor is entitled to one vote for each dollar owing to it. Practically speaking, this means that the power to approve or reject your consumer proposal can rest with just one or two of your largest unsecured creditors. That said, the cost of eliminating debts under a consumer proposal is typically around 30 cents on the dollar, where the debtor is then making payments directly to the trustee, who then distributes the funds to your creditors. So one warning I would impart about consumer proposals is that if you fail to make a payment under your proposal, and you fail to make it for a period of 3 months, then the proposal is annulled and a personal bankruptcy may in that case be unavoidable. I guess the major positive of a consumer proposal over a bankruptcy is that you actually get to keep your assets, including shares in a company that you may run and your home. It also only stays on your credit report for 3 years as opposed to 6 years with a bankruptcy. One last caution I would put out there with respect to consumer proposals is that you aren't entitled to credit during this period. And this is the most often reason why consumer proposals typically fail. As many as 1/4 of individuals who make a consumer proposal do not successfully complete it. But you can see how this would arise if you were a small business owner who is not incorporated, or if an unexpected personal expense comes up, like something like your car breaking down, wherein you need access to credit quickly. So with all of that said, I'm now going to take a look at the Q&A section. I thank everyone for listening to my presentation. This does bring me to the end of it. I hope that perhaps I've given some of you a different perspective on how to think about debt, and some insight into where leverage may lie with respect to negotiations on the same. If I'm not able to address any of the questions in the Q&A section, I've also got my contact information for anyone who may have questions after this presentation. So I'll just open the Q&A section here. That's a good first question, Kathleen. It is my experience with the Court of Queen's Bench is that it does not have mandatory mediation. Is that new? Yes, that is new. And I can advise that it is actually called mandatory mediation. And the reason for that is because in my experience, most clients, once they've gotten to the stage of actually bringing a legal proceeding against someone, they feel that all mediation efforts have failed and that mediation will not be a good use of their time and their legal resources. I can advise that in my experience, this is sometimes the case, but I have been surprised on many occasions by the effect of typically having two people who stop speaking with each other in a room to actually discuss what their dispute is. So mandatory mediation is mandatory. It's a required step before you can take a summary judgment against someone or complete any of those other necessary stages in the Court of Queen's Bench. And if you try to go ahead without it, the court will not let you, and that includes summary judgment. The only action you can take prior to completing a mandatory mediation to effectively end an action is to bring an application to strike. And those are very hard because essentially the test is there's no arguable claim on the other side. It doesn't really address the evidence. It addresses things or claims which are simply just bad in law, or defenses which are just bad in law. And the second question, also from Kathleen, thank you, is that is it true that a student loan stays as a debt forever? And there are, I mean, in terms of a student debt, typically, yes, student debts, they survive bankruptcy. And that's specifically in the legislation. I'd have to go into it a little bit more detail regarding typically, I believe it's debts, our student debts incurred after 1995, which are the most permeable on debtors and remain in effect. But before 1995, I believe that there may be an option for actually having those debts eliminated through a bankruptcy. But for most student loans you're dealing with, yes, they are going to survive even the most drastic step you might take to eliminate them. And that's just built into the legislation as a specific exception, along with fraud and child support and matrimonial payments, which I had mentioned there. I don't see any other questions. So I'm just checking here to make sure. Yes, I don't see any other questions here. So this ends my presentation, and I will stop sharing my screen. Thank you, everyone, for your attendance. And again, if there are any questions, please don't hesitate to contact me at my email there, or just phone me directly. Thank you.
Thank you so much, Nicholas, for that fantastic presentation. And thanks to those of you who took time out of your busy days to join us. Don't forget to check our events page at west.ca/events to register for the rest of the legal series webinars. Our next webinar will be happening next week, Wednesday, January 13th, and it is titled How to Properly Protect Your Business Name. Our presenter will be Luann Schlosser of Lunovel Law, and registration is now open on our website. Hope to see you then. Have a great afternoon, everyone. Thank you.